This hearing is officially called to order. I'm going to ask everyone to please silence their cell phones. And for those of you who have microphones near you, make sure that either your iPads or your cell phones are not near the microphones. It tends to have some effect on the recording. This is the seventh and the last of a series of 7 hearings that we are having by the Ad Hoc Committee to review the Criminal Justice Act. I'm Kathleen Cardone. I'm a United States District Judge for the Western District of Texas, and I am chair of this committee. Before we get started, I'd like to introduce the other members of the committee that are here with me today. I'm going to start with our first panel, Judge Dale Fisher, who is a United States District Judge from the Central District of California, Judge Ed Prado, Chair Emeritus of the committee and a judge on the Fifth Circuit Court of Appeals, Catherine Rowe, the federal defender for the District of Minnesota, and Professor Orrin Carr, the George Washington University. Also present from the committee are members who will be participating with us throughout these next 2 days. They include Judge Reggie Walton, United States District Judge in Washington, D.C., Judge John Gerard, United States District Judge from Nebraska, Judge Mitchell Goldberg, United States District Judge, Eastern District of Pennsylvania, Dr. Robert Rucker, Assistant Circuit Executive for the Ninth Circuit, Mr. Reuben Kahn, Executive Director, Federal Defenders of San Diego, and Professor John Gold, our reporter from American University. Not with us are Neil McBride, an attorney with Davis, Polk & Wardwell, and Mr. Chip Frensley, National CJA Panel Attorney, District Representative, and soon to be a United States Magistrate Judge. Also, let me introduce our staff. Ms. Erin Brenner, Attorney Advisor, Ms. Autumn Dickman, Project Manager. Our committee is pleased to be conducting this meeting here in Minneapolis. In planning our hearings throughout the country, it was our desire to have the opportunity to hear from all of our diverse judicial districts by setting up regional locations, and that would allow us to address all of the matters before our committee. In particular, at this 7th hearing, the committee wishes to have a focus on remote detention, tribal issues, and innovative defense structures from state criminal justice systems. Now, a brief history of our Criminal Justice Act. The Sixth Amendment guarantees to the accused the right to counsel in serious criminal prosecutions. To ensure that representation, it is now well established that after assessing the financial condition of the accused, the government may bear some or all of the cost of representation of that person. The responsibility for appointing counsel in federal criminal proceedings for those unable to bear the cost has historically rested with our federal judiciary. In 1964, the Criminal Justice Act, or what we call the CJA, was enacted. It established a comprehensive system for appointing and compensating lawyers to represent defendants financially unable to retain counsel in federal proceedings. It also authorized reimbursement of reasonable out-of-pocket expenses and payment of expert and investigative services necessary for an adequate defense. Amendments to the CJA in 1970 authorized districts to establish federal defender organizations as counterparts to federal prosecutors in those districts where at least 200 persons annually require appointment of counsel. It's now more than 50 years since that CJA was enacted. There are approximately 81 authorized federal defender organizations who employ lawyers, investigators, paralegals, and support personnel, and they serve 90 of the 94 judicial districts. Those federal defender organizations, in combination with more than 10,000 private panel attorneys, represent the vast majority of individuals who are now prosecuted in our federal courts. In April of 2015, I and my fellow committee members had the privilege of being appointed by John Roberts, Chief Justice of the United States Supreme Court, to serve on this ad hoc committee to review the Criminal Justice Act. In doing so, Chief Justice Roberts listed 14 specific issues for us to review. They include areas of judicial involvement in the CJA process, employment and compensation under the Criminal Justice Act, quality of representation under the Criminal Justice Act, and the CJA structure and effectiveness. This is not a first-of-a-kind study. Judicial Conference policy has long supported a periodic, comprehensive, and impartial review of the program. In 1967, the Judicial Conference and the Department of Justice gave Professor Dallin Oaks the sole responsibility of performing such an analysis. Then in 1993, a report authored by the Committee to Review the Criminal Justice Act, which was chaired by our Chair Emeritus, Judge Edward Prado, was presented to the Judicial Conference. It was a 212-page report. It described the historical evolution of appointed counsel in the federal courts, as well as presented detailed findings. It made 28 specific recommendations to improve the Criminal Justice Act program to include selection, training, evaluation, and compensation of panel attorneys, the establishment and management of federal defender organizations, CJA funding, and improvements to the administrative structure. Many of the Prado Review Committee proposals were endorsed by the Judicial Conference. It's now been over 20 years since that report. This committee is thankful for all of the work that was done by our predecessors, and in particular, we wish to recognize Judge Prado. His previous effort and the efforts of his committee has been an invaluable source of help in framing the work of this committee. I want to address for all of you a little bit about the framework of this study. The study is expected to be completed in the spring of 2017, when we will present it to the Judicial Conference of the United States Courts. Between now and then, this committee, with all of its collective experience and the views of all of its members, intends to gather information, examine the CJA program, debate the issues, and after thoughtful consideration, make recommendations to the policymakers. These findings and recommendations will be well documented and explained in a written report, and the report will be prepared by our reporter, Professor John Gould. It is the committee's hope that in today's world of computers, email, websites, we're able to sufficiently reach out to our stakeholders, give them the opportunity to provide us with ample information to document our study. For those of you who are not aware, the CJA committee has set up a website at cjastudy.fd.org, which allows anyone to inform themselves about this study and to submit comment. The committee has conducted a series of 7 public hearings. This series of 7 public hearings is in an effort by the committee to hear from a broad spectrum of individuals and organizations and to engage in discussion of the issues. The 7 public hearings have been as follows. Our first hearing was in November in Santa Fe, New Mexico. Our second hearing was in January in Miami, Florida. Our third hearing was in Portland, Oregon in February. Our fourth hearing was also in February in Birmingham, Alabama. Our fifth hearing was in March in San Francisco. Our sixth hearing in April in Philadelphia, and now our last hearing here in Minneapolis on May 16th and 17th. We're hopeful that the criminal justice community will come forward to present their views. All of these hearings are transcribed for the public record. The video and transcripts from our previous hearings are currently posted on our website. And again, our hearing today is being broadcast live through cjstudy.fd.org.